Good afternoon. My name is Shannon Rosner, and I have the honor of serving Chautauqua as Senior Vice President of Community Relations and General Counsel. It is my pleasure to welcome you to this afternoon's lecture with Reva Siegel, Nicholas Katzenbach Professor of Law at Yale Law School. Support for this lecture is provided by the Robert H. Jackson Leadership Fund, which was made possible as a Chautauqua lecture on the Supreme Court of the United States for the past 17 seasons, with today marking a return to the Hall of Philosophy after 2 virtual seasons of this lecture, and we are thrilled to be back in the Hall of Philosophy. Please join me in thanking the Jackson Center and its leadership led by Kristen McMahon, who I have long admired, for making this lecture possible. Introducing Professor Siegel is John Q. Barrett Cardozo Professor of Law at St. John's University, where he teaches constitutional law, criminal procedure, and legal history. Professor Barrett has produced extensive scholarship on Robert H. Jackson and serves as the Elizabeth S. Linney Fellow at the Robert H. Jackson Center. He is a graduate of Georgetown University and Harvard Law School, and I hope you will join me in giving Professor Barrett a warm Chautauqua welcome.
Thank you so much, Shannon, and thank you to the co-sponsoring Robert H. Jackson Center, and particularly to Arnie and Jill Bello, whose generosity supports this lecture. This is the 22nd straight year in which I've had the high honor to speak at Chautauqua in this forum or in the amphitheater, asterisk. You look so much bigger this summer than you did the last 2 on my Zoom screen. And it is so good to be back here in person with each of you. This introduction will touch 3 big, brief topics: Robert H. Jackson, this lecture, and this lecturer. Robert H. Jackson once was you. He was born in 1892 in Spring Creek, Warren County, Pennsylvania, south of here. He grew up in Frewsburg, New York, north of the state line, but south of here. He finished his high school education in Jamestown, New York, just down the lake, south of here. He never went to a day of college, but through apprenticeship and 1 year of law school, became a lawyer in Western New York, in Jamestown, in Buffalo, back in Jamestown, and rising to national stature, including in Albany, where he had a political relationship that was ripening into a friendship in the 1920s with the governor of New York, Franklin D. Roosevelt. And of course, for Robert H. Jackson, that led to big things. After Roosevelt was elected president in 1932, Jackson went to Washington, and he rose like a meteor. He was confirmed by the Senate for 5 different positions nominated by Roosevelt. He was, in 1934, appointed Assistant General Counsel of the Bureau of Internal Revenue in the Treasury Department. Today, we call it the IRS. He was detailed in 1935 from the IRS to the SEC, the Securities and Exchange Commission, to handle high-stakes constitutional litigation from that perch. And then in 1936, he was nominated to be an Assistant Attorney General in the Justice Department. And for a year, he headed the Tax Division, and then a year heading the Antitrust Division. In 1938, he was appointed to be the Solicitor General of the United States, the government's chief advocate in the appellate courts of the country, including the Supreme Court. In 1940, Jackson was appointed Attorney General of the United States, and he held that job for 18 months. And then in 1941, and a nice coincidence, July 11, 1941, 81 years ago today, Robert H. Jackson was appointed to be an Associate Justice of the U.S. Supreme Court. He was only 49 years old, which means he was more than 3 years younger than Justice Jackson, by which I mean Ketanji Brown Jackson, Justice Jackson, who in September will turn age 52. She is the 3rd Justice Jackson. I've just been telling you about the 2nd Justice Jackson, and in the 19th century, Howell Jackson, not much to say about him, was the 1st Justice Jackson. So we've now got a 19th and a 20th century, and now a 21st century Justice Jackson. Now, Jackson was at the Supreme Court 13 years, well, 12 years working at the Supreme Court, because for a year he was AWOL. By appointment of President Truman, he went away and missed an entire term of the court and served as the chief American prosecutor of Nazi war criminals at Nuremberg. But in the other 12 years of his 13 years before his premature death at age 62, Robert Jackson, as a Supreme Court justice, built a record, a reputation, a stature as an independent thinker, as the court's best writer ever, many would say, as a critic of judicial supremacy, which began in 1937 when he was an assistant attorney general defending the president's court-packing plan, but continued through his judging. He did not think the Supreme Court was constitutionally assigned to run the world. And he was also a judicial defender of fundamental individual rights under the Constitution. Now, he did not, I'll specifically note, ever vote or deal with the question of abortion. It was not a topic on the docket of the Supreme Court in Jackson's time. He did deal with bodily autonomy, and I want to flag a case which I encourage you to Google and read. His concurring opinion is 4 paragraphs long, called Skinner versus Oklahoma, in which the court in 1942, Jackson's rookie year, unanimously held unconstitutional Oklahoma's compulsory sterilization law for certain 3-time criminal convicted men. And the 9 men on the Supreme Court looked at this issue of the state forcibly performing vasectomies, and they said, no, it doesn't go under our Constitution. Now, that's a man thing, but I don't think it's a big extrapolation if you read Jackson's concurring opinion and think about Skinner to think that it is a personal thing and a bodily thing. This lecture commemorates Jackson's high stature forever in Supreme Court history, in American law, in public life, and through his Nuremberg work in world affairs. It is why Chautauqua inaugurated this lecture series in 2005 and schedules it, because Chautauqua happens in the summer, which happens to be after the court's term has ended, and is an opportunity for Chautauqua to bring a leading expert on the Supreme Court to bring an important mind and an important voice to address the Supreme Court as a topic for Chautauqua. Today's 18th annual Robert H. Jackson Lecturer here at Chautauqua Institution is Professor Reva Siegel. She is the Nicholas de Belleville Katzenbach Professor of Law at Yale Law School, her alma mater, Yale College, a master's degree at Yale and Yale Law School. She teaches constitutional law and various connected courses infused with legal history and a particular expertise and focus on people and social forces that are involved in our constitutional law. She is an expert on and teaches and writes, including scholarship and leading briefs, in the area of reproductive rights. And that, of course, is part of our constitutional law, including through decisions of our Supreme Court, and beyond them or above them or under them or alongside them in our own lives. And so it's really a high honor to welcome this year's Robert H. Jackson Lecturer on the Supreme Court, Reva Siegel.
So I'm delighted to be here in this incredible scene. I don't think I've ever given a lecture in as beautiful and as American a scene as this. It's genuinely a pleasure. You know, America's got a lot of troubles, but we should never, ever, ever stop counting its blessings, and this has to be one of them. So I'm grateful to Chautauqua for inviting me to give the annual Jackson Lecture on the Supreme Court this year. It's really remarkable to think of Jackson as a self-fashioned man of this region, reaching the heights that he did and the greatness he did, and teaching us that the Constitution is not just a piece of paper in the National Archives, but a living thing that's forged out of our experience as a nation from generation to generation in the crucible of democratic self-government, and to think of that understanding of our Constitution as being alive and growing and still being tested in our own generation today. I want to thank Shannon Rosner for hosting us here and for the introduction. And of course, I want to thank the Jackson Center, including Kristen McMahon, for the work, its co-sponsorship of the lecture, and I suppose most importantly, I want to thank Professor John Barrett for the invitation to present and for bringing my voice to this scene and to this community to talk to you about this term's opinion. I don't think that you could find a more enthusiastic emissary for the Jackson Institution and for Chautauqua as great institutions of American democracy. So today I'm going to be talking about the Supreme Court's end-of-term abortion decision. My lecture is entitled Living Originalism in the Dobbs versus Jackson Women's Health Organization case. Our Supreme Court has reversed many cases, but never has the Supreme Court reversed a right that the court itself had justified as important to a group's equal participation in the economic and social life of the nation. For those of you who don't recognize this quote, it comes from Planned Parenthood versus Casey, decided June 29, 1992, 30 years ago this summer. In Casey, a Supreme Court dominated by justices who were appointed by Republican presidents to reverse Roe, startled the nation by refusing to reverse Roe. As a reason to stand by Roe, notwithstanding their views on the constitutional and political merits, we can assume that many of them, if not all of them, the key votes thought that the opinion had been wrongly decided. These justices appointed by Republican presidents emphasized the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Yet on June 24, 2022, in Dobbs versus Jackson Women's Health Organization, the United States Supreme Court just upheld a law banning abortion after 15 weeks, and in so doing, announced that the court would now reverse its judgments in Roe and in Casey. The Dobbs court called the Casey court's concerns that the ability of women to participate equally in our democracy was facilitated by their ability to control their reproductive lives, this court said was merely speculative. Speculative was the court's word. Observing that courts do not substitute their social and economic beliefs for the judgment of legislative bodies. And then the Dobbs court observed, overruling Roe and Casey will not upend concrete reliance interests like those in cases involving property and contract rights. This is the entire passage that I've just, that was it. I kid you not. Both sides argued through articles, empirical studies, amicus briefs about the stakes of depriving women of control of their reproductive lives. Justice Alito didn't bother to address any of it, left or right, just waved it away as speculative, not concrete, not like a controversy in a contracts case. I mark this and will return to it as one of the many passages in the opinion in which Justice Alito might have demonstrated judicial statesmanship in addressing the nation about a divisive issue and chosen healing words. Instead, Justice Alito did exactly the reverse, speaking dismissively about matters that matter deeply to many, employing words that wound, simply because he had the votes to do it. Not only does Dobbs overrule a right the Casey court deemed central to women's equal participation in our democracy, the Dobbs court declares the Casey court's concern with women's reliance interests speculative, and most remarkably and conveniently, not even the kind of question a court should concern itself with. Considering the significance women have attached to the rights Roe and Casey recognized, considering the significance the Supreme Court itself had attached to those rights, Justice Alito might have at least paused to reaffirm that women were equal citizens, even if it was going to deprive them of their abortion rights. But did he? No. Everything in Justice Alito's opinion, subtly or not so subtly, goes out of its way just to send the opposite message. I will return to this theme in closing. Dobbs is the product of originalism. What might that mean? On the standard view, originalism is an interpretive method that tethers the Constitution's meaning to the deep past. Typically, originalism ties the Constitution's text to the understandings of the Constitution's ratifiers. But originalism may tie the Constitution's meaning to practice rather than to text, to the body of laws said to reflect the nation's history and traditions. Sometimes we encounter originalist hybrids of text and practice, as when, in Dobbs, the court interprets the Liberty Clause of the 14th Amendment in light of what the court terms history and tradition, and focuses on laws enacted at around the time of the 14th Amendment's ratification. Why interpret the Constitution in this backward-looking way? After all, this backward-looking mode of interpreting the Constitution is not the dominant mode of interpreting the Constitution. Far from it. Originalism is certainly not the prevailing mode of interpreting the Constitution's liberty guarantee, and was repeatedly rejected in doctrinal debates of the last several decades. Inside and outside debates over the Liberty Clause, these backward-looking claims have been expressly repudiated by many great jurists. To cite one, I quote the great Robert Jackson, for whom this lecture is named. He began his famous opinion in Youngstown Sheet and Tube versus Sawyer, addressing the separation of executive and legislative power, and I quote, "Just what our forefathers did envision or would have envisioned had they foreseen modern conditions must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh." And Justice Jackson rejected a formalistic, text-bound approach to separation of powers with the observation that, quote, "The actual art of governing under our Constitution does not and cannot conform to judicial definitions of the power of any of its branches based on isolated clauses or even single articles torn from context," close quote. That's in Youngstown. He advocated interpreting the Constitution informed by experience, not as a frozen text bound in history. But for originalists, there are compelling reasons for interpreting the Constitution in these clause-bound, backward-looking ways. Originalist methods are said to promote values of democracy and judicial restraint. The late Justice Antonin Scalia wrote in Originalism, the Lesser Evil, looking to history establishes an historical criterion that is conceptually quite separate from the preferences of the judge himself, close quote. Justice Scalia was arguing that originalism provided judges objective methods by which they could decide cases without regard to their own personal commitments. The originalist claims that judges employing originalist methods are employing a value-neutral method that will promote the separation of law and politics because a case can be decided without respect to the commitments of the individual interpreter. My thesis here. Originalists may claim their methods of interpreting the Constitution will cleanse the Constitution of politics, but in my lecture today, I will be asking us to recognize what all politically literate Americans already know in an emperor's new clothes sort of way. Originalism is not simply a value-neutral method of interpreting the Constitution. Originalism is also a value-laden politics, a multi-decade political project of the conservative legal movement embedded in the Republican Party, whose announced goal is reversing Roe versus Wade. In the opening portion of my remarks, I will be discussing what we see in originalism when we look at the tensions between these two pictures of originalism. Originalism as a value-neutral method of interpretation that separates interpretation from the values of the interpreter, on the one hand, and originalism as a value-laden version of interpretation that is involved with the political goals of capturing the courts to accomplish particular ends, like overturning Roe. That version of originalism is committed to changing the law of the Warren and Burger courts and is very much entangled with goals, values, and commitments. In the second part of my lecture, I want to talk about how understanding originalism as both a politics and a method explains how the court reasoned in Dobbs. Understanding this second picture of originalism as shot through with values gives us a lot of explanation about the way the court is reasoning in the abortion case. It helps us understand why the court used a history and traditions analysis to upend half-century of law, and instead of offering the narrowest possible explanation or justification for overturning the abortion right, adopted a very broad history and traditions justification that implicated a whole swath of rights and not only the abortion right. So not a narrow overturning, but a very broad overturning. First, the history of originalism. I'm going to revisit it in the Reagan years. Originalism took shape in the Justice Department of the Reagan presidency in the 1980s before originalism was elaborated as a method of interpretation in the legal academy. In 1980, as Reagan campaigned appealing to Americans threatened by social change, he invoked the Supreme Court as responsible for threatening America's traditional ways of life. He figured himself as America's great defender, which put him in battle with the Supreme Court. Reagan and the Republican Party promised to fix the problem of runaway federal courts directly by appointing judges who would simply restore traditional ways of life threatened by what they saw as adverse decisions of the Warren and Burger courts. In 1980, for the first time and continuously ever since, the Republican platform promised that, quote, "we will work for the appointment of judges at all levels of the judiciary who respect traditional family values and the sanctity of innocent human life." Notice that that platform plank was in the Republican platform in 1980, and a version of it has been there ever since. First and most importantly, this history shows that overturning Roe is a goal of originalism as a political practice and not just the result of applying originalism as a value-neutral interpretive method. Secondly, and perhaps just as importantly, this history shows that the assault on abortion is not only about abortion. When President Reagan's supporters mobilized against Roe, they were concerned to protect the embryo fetus, but they were also seeking to prevent something they called family values, the understandings about sex, sexuality, and religion that shape a community's traditional ways of life. Third, originalism began as a practice of change in the executive branch through appointments of judges screened to accomplish the policy aims and transformative constitutional vision of the executive branch. It was about appointing judges. Today, we may think it normal for candidates to solicit votes for judges whom a candidate will overrule automatically, as candidate Donald Trump promised in 2016. But the exchange was norm-busting when first proposed by candidate Reagan in 1980 and occasioned controversy on the campaign trail and during his first years in office. President Reagan sought openly to transform judges into instruments of the executive branch. Notice how this version of originalism is committed to goals and is not independent of views. It has an aim. Originalism's claim of constitutional restoration, of getting back a traditional way of life, offered a framework in which Republicans could speak from fidelity to the Constitution as they promised voters to appoint judges who would implement the voters' policy goals. Through originalism, judges Reagan and subsequent Republican administrations were appointing were implementing values of concern to contemporary voters and not just to the founders. They appealed to a deep past as a reason to make new appointment of judges who would change the law to accord with family values, contemporary conservative mores. So now I go to Dobbs, the opinion itself. And I'm going to argue that Dobbs is an exemplar of originalism as the right's contemporary living constitution. Justice Alito's opinion in Dobbs, joined by Justices Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, follows a kind of originalism in tying the meaning of the 14th Amendment's liberty guarantee to the distant past, even if it doesn't purport to identify the meaning of the amendment to the voters who ratified it. Rather, Alito follows a case called Washington versus Glucksberg, which was decided in 1997, and interprets the 14th Amendment's guarantee of liberty in light of the nation's history and traditions. According to this view, only rights deeply embedded in this history are protected, and the right to an abortion the majority ruled is not. Justice Alito claims that tying the meaning of the 14th Amendment's liberty guarantee to America's history and traditions prevents the justices from imposing their own views on the case at hand. Quote, in interpreting what is meant by the 14th Amendment's reference to liberty, he writes, quote, we must guard against the natural human tendency to confuse what the amendment protects with our own ardent views about the liberty Americans should enjoy, close quote. My first point, a necessary condition for the Dobbs decision is originalism understood as the Republican Party's strategy of constitutional change through judicial appointments. When I call Dobbs an originalist decision, I include within my account of originalism the appointments practices that produced the court that decided the case. Because in the absence of the appointments practices such as these, engineered by the Republicans in the lead up to the decision, there would be no reversal of Roe. It took the current Supreme Court array to be willing to reverse Roe. Donald Trump campaigned in 2016 with a list of Federalist Society screened nominees whom Trump promised voters would overturn Roe, quote unquote, automatically, in my opinion. His nominees, Justices Gorsuch, Kavanaugh, and Barrett, were confirmed in increasingly contentious hearings. I won't recount all, just two. In February of 2016, when Justice Scalia passed away, Senator McConnell advanced a rule to block hearings for President Barack Obama's nominee, if you will recall Merrick Garland. McConnell claimed February hearings for Merrick Garland were out of bounds because they were taking place, quote unquote, during an election year, Senator McConnell claimed. But then, remember, in September of 2020, when Justice Ginsburg passed, Senator McConnell abandoned his Garland rule to rush through a hearing for Amy Coney Barrett, literally in the midst of mail-in voting. As Nicholas Goldberg observed in the L.A. Times, quote, the same Republican senators who in 2016 refused to consider Merrick Garland's appointment to the Supreme Court because with 8 months to go it was supposedly too close to the presidential election, have now confirmed Amy Coney Barrett with just 8 days left before the election. This is so unprincipled, so inconsistent, and so cynical, the LA Times observed, that it defies the imagination. It is just the flip-flop of the century undertaken for one reason. Barrett's confirmation ensures a conservative majority on the high court for the foreseeable future. In the end, the only principle that explained the Republicans' approach to the Garland and Barrett appointments was the principle to ensure a court, and I will use the word pack the court. Here I use the term advisedly in light of the differential treatment of the Garland and Barrett nominations, so as to ensure that the court would be an instrument of Republican will at whatever cost to its legitimacy. Note the differential standards for appointment. That set of nominations, it turns out to be absolutely critical for the overruling of Roe, which I'm going to go on to describe. So this appointments sequence is part and parcel of the originalism that I'm describing. So that was point one. My second point, there was no authority for the Dobbs decision in the United States reports until this hardball nomination strategy produced the court to change the law, meaning without the nomination sequence I just described to you, no court is willing to change the law. President Trump's new justices then reasoned with a Mitch McConnell's sense of the rule of law to sweep away the existing law. One body of law that they swept away was 50 years of precedent for the abortion right, 49. With different members of it, the Supreme Court had affirmed and reaffirmed Roe innumerable times over a half century, In 1992, the Supreme Court had reaffirmed and narrowed Roe in its surprise 1992 Planned Parenthood versus Casey judgment. The court had extended the abortion right again as recently as 2016 in Whole Woman's Health, and the court had reaffirmed Roe yet again 2 years ago in 2020 in June Medical. So constant reaffirmation of the abortion right. Judges' reasoning from ordinary Article III role morality and ordinary sense of professional craft would not overthrow a case reaffirmed that many times and as recently as that, merely because the court's membership had changed, let alone had changed under such dubious and contested circumstances as I have just recounted. Chief Justice Roberts, who is no fan of Roe versus Wade, struggled long and hard throughout the pendency of the Dobbs litigation to try to uphold the Mississippi 15-week ban without overturning Roe versus Wade. Indeed, the dominant theory for the leaking of the Dobbs draft was to prevent the Chief Justice from persuading a member of the majority, likely Justice Brett Kavanaugh, to join the Chief Justice in a plurality opinion that would have upheld the Mississippi statute under a much narrowed version of Roe and Casey. In other words, the Chief Justice, who was a critic of Roe versus Wade, no friend of the case, thought for the institutional legitimacy of the court that Roe should not have been overturned. A Republican critic of the court, a critic of the opinion, trying to preserve the institutional legitimacy of the court, was trying to save the decisions, not necessarily even in the long run, but at least in the short term. He failed. Trump appointees would have none of it. They now had the votes to overturn Roe, they had the power, and they planned to exercise it. As Justice Thomas explained in the period just after the draft opinion leaked, this is a quote from Justice Thomas, "I always say that when someone uses stare decisis, that is to say, preserving the precedent of the court, that means they're out of arguments," he said. "Now they're just waving the white flag, and I just keep going." Justice Thomas really said this to New York Times reporter Adam Liptak. It was in a column Liptak published May 14, 2022. Question, simply because inquiring minds want to know, was the Dobbs draft leaked to prevent Chief Justice Roberts from saving Roe? My third point, Dobbs is a living originalist decision, not simply because it reverses Roe, long a goal of the originalist movement, but because of the sheer breadth of the grounds on which the Trump court reversed Roe. A judge exercising the ordinary professional craft or role sense of an Article III judge would normally not reverse Roe given the numerous times the decision had been reaffirmed and the equal participation rights the decision protects. Or two, if reversing Roe, the judge would overrule a half-century of precedent cautiously, by steps. That is what Chief Justice Roberts was apparently trying to do. It might try to leave open a door to federal courts for women whose due process and equal protection rights to life and health might be threatened by the overruling, for example, women in ectopic pregnancies or miscarrying. Or, if reversing Roe, might write a decision in every respect narrowly, focusing on the differences of the abortion right from all other liberty rights, either emphasizing the fact of potential life or possibly the divisiveness of abortion. So distinguishing abortion from all other liberty rights. Instead, the Dobbs majority reversed Roe on broad-based social movement grounds through a history and tradition analysis that paradoxically lacked any Burkean respect for established practices, understanding originalism as this political practice, as the outgrowth of a 4-decade conservative legal movement, explains why the court went broad in this history and traditions analysis, seeking to upend not only the 50 years of abortion rights, but through a broad-based justification that's inflammatory in the way that it reasons and threatens myriad other rights, as I'm about to start to describe to you, meaning reasons about the grounds of the decision in a way that threatens not only the abortion right, but potentially other rights in addition to the abortion right. So here's this next third point. Though Dobbs never acknowledges this, in reasoning from history and traditions, the Dobbs opinion is not reasoning from established law under the Due Process Clause. Though he never acknowledges it, Justice Alito is reasoning from the arguments of the dissenting judges in the abortion and gay rights cases. So he's not arguing from established law, but from the dissenting opinions in the abortion and gay rights cases. Before Dobbs, the Supreme Court had interpreted the 14th Amendment's guarantee of liberty in an evolving way, meaning they understood liberty in a way that Americans today understood liberty, not the way that Americans in the 19th century understood liberty. That's why it covered a whole host of rights that Americans in the 20th and 21st century understand and recognize. Dobbs' backward-looking history and traditions analysis threatens to discredit many decisions ranging from the right to interracial marriage, that's Loving versus Virginia, to the right to contraception, that's Griswold, to the right to same-sex intimacy, that's Lawrence versus Texas, and the right to same-sex marriage, that's Obergefell versus Hodges. None of these decisions is easily upheld under the kind of history and traditions analysis that the majority practices in Dobbs. Recall that Justice Alito claims that tying the meaning of the 14th Amendment's liberty guarantee to Americans' history and traditions prevents justices from imposing their own views on the case at hand. Quote, interpreting what is meant by the 14th Amendment's reference to liberty, he writes, we must guard against the natural human tendency to confuse what the amendment protects with our own ardent views about the liberties that Americans should enjoy. But Dobbs shows why these claims are wrong. A judge's turn to the historical record can just as easily disguise judicial discretion as constrain judicial discretion. Dobbs's history and traditions method reads 1980s Republican-era family values into 1868 legal materials, which is why I titled my lecture Living Originalism in Dobbs versus Jackson Women's Health Organization. Originalism is living constitutionalism, but it is not forthright about its values, aims, and commitments. In Dobbs, the Trump court defines the Constitution's protections for liberty largely with reference to laws enacted in mid-19th century America. During that period, which Justice Alito selects, conveniently enough, there was a campaign to ban abortion across the nation. That is to say, in mid-19th century America, the focus of his opinion. Alito also includes an appendix enumerating many of these state statutes. Alito's account of the nation's history and traditions in matters of abortion is both shaped and whitewashed to justify the normative results, the argument of his opinion. His account of the nation's abortion laws underplays or discounts common law at the founding and in the early republic, meaning in the late 1800s and the late 1700s and early 1800s, at which point abortion was criminalized only after quickening, as late as 16 or 25 weeks into pregnancy. So there was access to abortion in the early years of the nation, but this is not emphasized in the opinion in the early years of the nation. In focusing on the campaign to criminalize abortion in the mid-19th century, Justice Alito also provided an incomplete account of that campaign. He wrote, for example, that opposition to abortion in those laws was sincere. It's fine to say that opposition to abortion in this period was sincere, but it's not helpful in the sense that during this time period, women were denied the vote and were denied virtually all rights in marriage. And one can assume that in denying women the vote and denying people of color the vote, that the persons who did so were also sincere, but it doesn't really help us know whether we want to defer to their views of the matter today. During the 19th century campaign against abortion, advocates for laws banning the practice argued they were necessary to enforce women's maternal and marital duties and to protect the ethno-religious character of the nation. They were actually anti-Catholic, among other things, but I'm not going to go into that now. Claims about, it was a nativist period, so there was obsession about relative birth rates in this campaign, of all things. Claims about protecting unborn life were not freestanding as Alito claims, but deeply entangled with constitutionally suspect judgments, as documents from the period make clear. In all of this talk of tradition, Justice Alito evades a fundamental question. Why should the 19th century anti-abortion laws limit the way we understand the Constitution's liberty guarantee any more than the history and traditions of segregation limit the way we understand the Constitution's equality guarantee? Like, why should we defer to this history now? Why let this past rule us? Why not aim higher and better? There is no good reason. The problem with anchoring the meaning of our commitments to this past, as Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan put it succinctly in dissent, is that, quote, the men who ratified the 14th Amendment and wrote the state laws of the time did not view women as full and equal citizens. Do those justices who joined the Dobbs majority? The Dobbs majority signed on to an opinion in which decisions and laws written by men was presented as Americans' history and traditions without a single woman's voice represented, and which claimed those traditions were sufficient to justify women today of a half-century of constitutional rights. This is not an account of history that is, quote, conceptually separate from the preferences of the justices himself, close quote. It is a history that expresses judicial preferences as the nation's traditions. The very justices who urged this approach to interpreting women's due process liberty rights would not advocate it for their own First Amendment speech rights. This is not the way they interpret the First Amendment, or their own First Amendment free exercise rights. And they will not use this method next fall when they go to get rid of affirmative action under the Equal Protection Clause. Meaning this is a selective standard used to kill abortion rights, which is not used consistently throughout the Constitution. So there is no good reason for applying it here. I do not advocate employing a history and tradition standard to interpret our constitutional provisions today. But if we are to employ one, we need to be very careful about what counts as evidence of our history and traditions, what periods we look at, and whose voice counts. This, the majority, of course, did not do because of the results it wished to reach. Had anyone bothered to look outside the statute books, they could find plenty of evidence that Americans in the 19th century demanded autonomy in decisions about parenthood, just as they do today. These demands were passionately expressed both in the abolitionist movement and in the women's suffrage movement. Women may not have had authority to vote, but they certainly had views about the importance of voluntary motherhood. If the Supreme Court wants to tie the meaning of liberty to the nation's history and traditions, it needs to include the voices of the disfranchised in such an account, unless it means to perpetuate their disempowerment as part of the present Constitution. To conclude then, this is, as I have said, deeply an expression of originalism at its most political, and at its least conservative in the small c sense. I read Dobbs as an opinion that is not only destructive of a half century of women's rights, it's destructive of women's rights not merely because it overturned Roe, but because of the spirit in which it did so. The Dobbs court did not act cautiously, respectfully towards those whose rights it was denying, but almost mockingly, with an exhilaration of power. The court did not exercise the authority of the court, accumulated over the centuries, cautiously, but instead almost cavalierly, in ways that are destructive of the accrued legitimacy of the Supreme Court as an institution. And acting in the midst of a set of highly fraught social conflicts, the court did not act cautiously asking mutual recognition and respect from different sides of a conflict-torn nation, but instead proceeded in ways that are almost designed to inflame the body politic at a time when the nation, as a nation, we can least afford it. Certain passages of the opinion simply stunned me to read. I thought, okay, you guys, you've got the court. Can you please act like justices, please? But the opinion is just unrelenting in its exaltation in the exercise of power. But there's something to remember here. This is not a court speaking for the nation. More than half the nation did not want the court to reverse Roe. And the court is not even speaking for history and tradition if we take into account not only the formal law, but also the legally voiceless, all of we the people. The court in Roe did not invent the abortion right. It was giving legal shape to intuitions about liberty and equality that reach back centuries, that reach back into the institution of slavery and segregation, that reach back into the common law of marriage, that gave married women no rights in her own property, no rights in her earnings, no right to say no to her husband's sexual advances. But from the abolitionists and the suffrage movements of the early 19th century, there have been women and there have been men who sought the ability to control the shaping of their family lives as a matter of liberty and equality. They too are part of this nation's history and tradition, whether this court will recognize it or not. And what this court did not in the end create, it cannot destroy. Understandings of freedom and equality will continue to grow, no matter what Sam Alito says. Voting rights are repro rights. That is what the suffragists said. The state are the people, so to the internet, and so to the streets. Again, what the court did not create, it cannot destroy. And in the decades hence, in conversations, we will reshape what it means to build families respectfully, using law in the proper ways it should be used. And I'm going to thank you with that.
Wow. I do want to spend all of the time we have, which is about 14 minutes, on your questions. We've got a line, a lot of people, so I would ask, as always, please keep your questions succinct. And to the extent you need context, please try to keep that as succinct as possible. Thanks.
Justice Ginsburg wrote in some of her writings that she was apprehensive about the way that Roe versus Wade was written. Can you help us understand why she was so apprehensive and why that wasn't corrected somewhere between Roe versus Wade and the present?
Is this on? Okay, yeah, you can hear me. If you'll excuse me, may her memory be a revolution. Okay, you can hear me now. So she said lots of things, many of which have been deeply moving to me, not all of which I agree, but I'll give you a riff on that. So the first thing that Justice Ginsburg was focusing on was that she thought that the abortion right should have been expressed as grounded in equality rather than liberty. And actually, when I was a little baby law professor, and without this, and I first started writing about abortion, it was before the Casey decision, when Casey was supposed to overturn Roe, and not knowing anything about her writing, which is kind of wild, but when I went to law school, there were only basically men as law professors, so nobody told me any of this stuff. There was one woman professor. I wrote a paper arguing that abortion should be grounded, even if they overturned Roe in Casey, abortion should be grounded in equality. And I have basically been an equality person my whole life. I agree with her. I actually put in an equal protection brief in the Dobbs case, and in one of the many passages I cut out of my talk today to keep it short so that we could do this by talking rather than my talking at you. There was no equal protection claim in this case, but Justice Alito was sufficiently nervous about our equal protection amicus that he tried to reach out and say there was no good equality claim. And he said, precedent constrained the court from reaching equal protection, which was kind of one of his own the libs, ha-ha lines, because he was busy overturning 50 years of abortion rights. So the idea that precedent was going to constrain him there was one of his ha-ha lines. But I cut that part out of my talk. So anyway, so the point is, I agree with her that liberty and equality are each grounds of the abortion right. There will be equality claims, both federal and state, to come. It's stronger, in my view, and in her view, because it allows you to tie the stakes more directly to other forms of inequality in women's lives, both as to the circumstances in which they conceive, gestate, and rear children and make their way in the market, in education, and in politics. And for those reasons and the greater legitimacy of the Equal Protection Clause as a piece of constitutional text, it has greater strength. So for all those reasons, that's what she was talking about. It's more inflammatory in certain respects, because if you say that's the stakes for women, it gets people really riled. I don't think it makes it less conflictual, as she sometimes suggested. I don't know that that follows, but it's a powerful argument, and I've made it. And I'll just say what I said about Mississippi was that they had lots of things they could have done for the women of Mississippi besides use the criminal law. They could have used to help women's health and unborn life. They could have provided access to sex ed, to contraception, to health care, to social assistance, and to child care, of which they provided nothing. 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 Highest infant mortality rates in the country. And they claimed there was nothing that the law allowed them to do wrong. So that was the shape of our equality argument. So I'll just leave it at that, because there are other people with questions.
I think you have to get it.
This way. Hi.
This morning, the editorial board of the New York Times called upon Chief Justice Roberts to resign. I'm wondering if we do get to elect another justice, whether or not lying before Congress under oath during their confirmation process, will that become some way to get rid of these people?
Since I did not read the New York Times, would someone else want to? Will someone who's read the Times, because I can't pass on what was said there.
They just asked him to resign, saying that they knew he wouldn't, but he should.
Well, there are going to, by the time next term is done, there are going to be so many conversations about the shape of the court. I mean, the number of, this court shows no judgment about the conflicts it's getting into, and the dynamic of this opinion, the gun opinion, what's coming with affirmative action, voting rights, and the independent state legislature theory is going to produce, it will make 1937 quiet times.
That is my question. What are the chances of expanding the court to perhaps undo some of this?
I think that there are many forms of response other than expanding the court. There are going to be, the Democrats have not yet come on board with a ground on which they're united. And what needs to be is some ground on which people are united for any response to be effective. I will simply say that is the key factor.
I think there's something there.
Yeah, well, thanks for such a great analysis of the majority opinion, which really ignored the needs of women and the health of women, and which Roberts didn't do. Roberts at least addressed that. But on the converse, the dissent really did not address one of the key points in the majority opinion, which was the unborn child, life of the potential life. And that's something that Blackmun did address in Roe versus Wade, repeatedly, was the value of the potential life. And I'm wondering if you had been writing for the dissent, how you would have dealt with Alito's strong arguments on, the state's right to protect, or the state's goal or need to protect fetal life.
If I had been writing, I would have immediately called into question the assumption that the state needs to use the criminal law first as opposed to last. I'm fascinated by the fact that it's assumed that the only way the state can intervene is by that mode, as opposed to by in my writings for years now, I've advocated expanding the frame and looking at the full complement of tools available to a state concerned to protect the health of women and of the next generation. And I would insist that the approach be holistic in that way. And I would actually observe that if one looked at judgments outside the United States, that is the direction that many are trending, including most recently the judgments of the Colombian court. So we just assume that the only way to protect unborn life is by the use of criminal law trained on controlling women, even though it's fairly clear that in jurisdictions with criminal bans, they're not very effective at achieving those ends. And it's time that we stopped having that fetish of a carceral approach and use this more expansive approach.
Now that the issue of abortion is now with the states, it would seem likely that states like Texas, for example, will perhaps criminally charge abortion providers in New York with violations of a Texas criminal statute, or bring civil actions against them. To what extent will that broad reach, long arm reach of these abortion protection or prevention statutes stand muster in the current court under the full faith and credit clause or the right to travel clause? Or that's not a clause, but the right.
So there's a pretend at the root of Justice Kavanaugh and the majority's view that they can just send this all back to the states and it's all going to go away. And that's not going to happen. There's now going to be years of constitutional litigation while there's a big fight to figure out exactly whose law can reach into whose jurisdiction. And that's the shape in which one big strand of these debates is going to unfold. It's not at all a settled question. Justice Kavanaugh's opinion suggests that there is a right to travel that's going to settle some of these debates in a way that will allow for movement, but not after a long, messy litigation process. There's a paper by David Cohn and Rachel Rubush that's out now that's testing a lot of these theories, but they're all going to be open in litigation in the years to come.
Thank you.
One more.
I have so many concerns about this. One of them is that the court is really already packed, in my view. There's 7 Catholics on it, 1 Jew and 1 Protestant who was Justice Jackson. So it's really already packed. And so what's wrong with repacking it?
I'm not, so that's both the religion conversation and the size of the court conversation. One thing that I am going to say in deep earnestness, if there's going to be a conversation about intervening in the court, there needs to be a convergence amongst interested court engagers about the direction in which it's going to move, whether it's going to be by way of having much shorter terms for the justices or having a larger court and getting into a bidding war between parties about the size of the court. And I'm not standing here with the results so much as I'm looking to have some kind of convergence of views so that the intervention is effective rather than ineffective. That's where I'm going to lead things. One more? Okay.
I think one of the next big decisions we're going to have is state voting rights, the right of the state legislatures to establish districts, and whether majority vote in the various states will control the selection of the electors in the Electoral College. Traditionally, now, I believe the states follow the majority vote of the states, but I think the conservative Republicans have already got control of most of the swing states. And do you think that that traditional way of electing electors is going to change so that the state legislatures will select the electors instead of the majority vote of the states?
So I think I know where I want to end this. And it's not by my having the ultimate solution at a tactical, strategic, or predictive level to our politics, but rather in a different way. So in the 19th century and the early 20th century, there were women who fought for the vote, and they did not necessarily, the question of abortion rights as such was not in play. They did argue about their ability to have control over the question of sex in marriage and the spacing and timing of their kids, but the real issue was their ability to have access to the ballot. And access to the ballot was their ability to control the circumstances of their home lives, their children's lives, and depending on where they were in the class structure and the race structure, the welfare of their families. And voting was the key to the flourishing of family life, however one conceived it, to sexual well-being, to family well-being, to community well-being. And that's where I was riffing at the end of my comments when I said that voting rights are reproductive rights. And I think I want to say something that I said in a Zoom with folks who were asking about Dobbs from all over the globe on Wednesday night, which is that our democracy is deeply in trouble right now. We all know it. And it's in trouble both because of the infrastructure of representation is so challenged and fraught, and it's in trouble because we're so divided as a nation, because as a community we don't trust each other. And I would say that the future of our finding our way to deal with all of these questions when we don't agree with each other and the whole system of voting is so fragile and our court system is so messed up, all of it depends really on our saving our democracy. Saving the planet depends on saving the democracy. Saving reproductive justice depends on saving the democracy. And really doing that is all about a matter of trust. And when I talk to you about this opinion, for years, I mean, back 2016, earlier, I knew that Roe was toast, but I never expected to hear it done in the tone that it was done. And I think what I want to say in closing this talk is that we really have to find a way to talk to one another if we're going to save this enterprise. And so much depends on that. So it's a trust thing.
Welcome to CHQ Assembly, the digital expression of Chautauqua Institution, where you can explore the best in human values and the enrichment of life. We invite you to take part in this worldwide community of lifelong learners and lovers of the arts, education, interfaith, and recreational programming. Throughout the year, we'll be adding new programs and events to CHQ Assembly that you won't want to miss. We encourage you to also invite your family and friends as we continue to widen the reach and impact of Chautauqua's mission.
CHQ Assembly is made possible through the collaboration and innovation of Chautauqua Institution's full-time and part-time staff, seasonal staff, and many volunteers, as well as participants like you, whose engagement, gifts, and subscriptions sustain our mission.